Come on up, sir. You're Corey Grant. Come forward. Mr. Grove is your attorney. You've got two cases here that we're working on. Number one is cause number 23-41455, a second amended motion to revoke probation filed April 21st of this year, and an indictment handed up last year, August 28th of 2024 in 24 CR 1811. Alleging state jail felony of illegal possession of a controlled substance, namely methamphetamine. And the second amended motion to revoke probation in 41455 begins with the allegation that on April 3rd, 2023, in this court, you were sentenced to 10 years in prison. That was suspended. You were placed on regular probation for 10 years for engaging in organized criminal activity, a second-degree felony. And then allegation number one alleges you committed the offense of illegal possession of a controlled substance that's recognized in 24 CR 1811, the new indictment. Two, illegally possessing methamphetamine.
I think that's the same date, Judge.
Yeah, it is. 4, failing to provide verification of entering and successfully completing moral reclamation therapy. 5, committing the offense of failure to ID on or about March 8th, 2025 in Jefferson County, Texas. 6, failing to report to the probation office for the months of December 2024 and January, February, and March of 2025 in violation of your probation order. 7, illegally possessing drug, namely tetrahydrocannabinol, on or about May 8, 2025. 8, being at a location other than your residence at approximately 1:10 a.m. in violation of your curfew order in your probation order on or about March 8th of 2025. We're not going to talk about the money. So do you understand what you're charged with here in these two matters, sir? Do you understand what you're charged with in these two matters? Okay. Raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God? I'll lower your hand. This second amended motion to revoke probation, does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, Your Honor.
In summary, once again, Mr. Grant, and you were Corey L. Grant.
Yes, sir.
This motion states that on April 3rd, 2023, in this court, you were sentenced to 10 years in prison, probated for 10 years for the second-degree felony of engaging in organized criminal activity. Is that true? All right. Number one states you committed the offense of illegal possession of a controlled substance on or about April 16th, 2024 in Jefferson County, Texas, in violation of your probation order, and that was namely methamphetamine. That is also what is recognized as the allegation in this new indictment of August of 2024 in 24 CR 1811, charging you with the state jail felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you're charged with in this, sir?
Yes, sir.
Is this allegation true or untrue?
True.
Are you pleading true to it voluntarily and because it is true as it is alleged?
Yes, sir.
Do you understand, sir, that a voluntary and knowingly made plea of true to one or more violations of probation, that is enough to grant a motion to revoke probation? Your probation, in this case, could be revoked. You could then be found guilty and sentenced to the full range of the second-degree felony, which is no less than 2 nor more than 20 years confinement in prison. Knowing that, your probation can be revoked. You were placed on regular probation. You were found guilty already on April 3rd, and we suspended the term of probation of 10 years and placed you on regular probation. What can be done is your probation can be now revoked, and you could be sentenced to no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes,
nonetheless, to allegation 1. I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true to this. Is there a agreement?
No, sir.
Okay. All right, go ahead. Then Mr. Grove on behalf of Mr. Grant.
Is that the only ground account?
That's all we're gonna go on.
Okay.
This new indictment, yeah. I think that's all that's necessary, right? Yes, sir. Go ahead.
You are the court grant, right?
Yes, sir.
And you're under oath. You understand that. You were arrested by the Beaumont Police on April the 16th, 2024 in Jefferson County, Texas, weren't you?
Yes, sir.
Okay. And why were you arrested?
Legal positions.
All right. Were you there with some other people?
Yes, sir.
Who else were you there with?
With my girlfriend, a friend.
All right. And then the police stopped you to search you. Is that right?
They was running my name to make sure I had no warrants, but they was there for another guy that I was there with.
Okay. They weren't there looking at you. They were there looking at this other guy, but you were there too. So they had you under supervision and they were watching you,
Yes,
right? Okay. And then what happened?
They came asked for our names, run our names, and that's what we never. Then that's when I realized I had to do my position.
Okay. What drug did you have in your possession? And then what happened? Okay. You tried to dump it on the ground and the police found it there. Did they ask you about it?
Oh, he just picked it up. After they realized, well, he said they seen me on camera tossing it. So after he picked it up, he had handcuffed me. So
Good. And then did you have some other warrants too?
right that day,
No, what day?
I got arrested.
And how long? That was back on April 16th, 2024. And how long have you been in jail? The entire time?
Oh no, I was in a 3 station.
You got out after 3 days? How long have you been in jail since then? After you got rearrested? Let's guess.
I've got the numbers. If you want to know for the record.
Yes, sir.
He's being credited with 167 days on the motion to revoke probation and 88 on the new case.
And the judge's records show you were in there 168 days on the motion to revoke probation case. Does that sound accurate? Now, as you know, the judge has the right to revoke your probation if he chooses to do so, and he can send you to prison for the maximum term of your probation. What would you ask the judge to do in punishing you for possession of this methamphetamine?
Like I would like to give me stated to conceive my probation. But I would want to seek the time like for a position charge, hold my probation case, do the time for the position and get out to conceive my probation, TDCs for a charge. Probation.
Let me see if I understand what you're saying. You'd like to be convicted and given a conviction for the state jail amount of methamphetamine possession. And after you serve the time on that, you would like to be reinstated back on this probation that Judge Stevens is having this hearing on today. That's what you're saying?
Yes, sir.
Okay. And why do you want to be reinstated on probation for the engaging in organized criminal activity that went before the court on today?
So I would like to start to complete it and be home with my baby mama to take care of my kids, and I don't want to go to prison because it's not for me.
Okay. The judge gave you some additional conditions of probation. Would you follow those?
Yes, sir.
Anything else you'd like to tell the judge about why he ought to consider going with your requested keeping you on probation in the case you're currently on probation on engaging in organized criminal activity?
Yes, sir. Because I made a mistake having possession of the juror, knowing that I violated my term. I'm not supposed to have it. I'm not asking for second chance, but I'm asking for help. So I had it to smoke during the time I was going through. But I can make my payments that I owe up to, and I would like to finish my classes.
And that was a ground that was not before the court on this motion to revoke probation, but you have a considerable arrearage in your case. Is that correct?
Yes, sir.
And you'd like to be able to pay that.
Yes, sir.
Anything else?
State.
Your Honor, state asked you to revoke him in this case and sentence him to 8 years TDC. Believes he possessed methamphetamine again after being given a chance on probation. That's exactly the kind of things that lead to the engaging in organized criminal activity, getting on these drugs, going, stealing things. That's exactly what he's getting back to doing the drugs while he's on probation, not showing up, not reporting, and then also, again, failing to ID when he was actually pulled over by an officer there. So it's continued on all the way through a second amended motion to revoke. And I believe he has been given a chance. He failed at that, and state's asking for 8 years TDC.
Anything else?
Just very briefly, Judge, I would point out to the court that the amount of methamphetamine involved in the new case was a stage yellow amount. I don't know the exact weight, but it would have been less than a gram. Failure to ID by the defendant was on another date, and we didn't address that or weren't given the opportunity to address that. And I'm not sure it would change the court's ruling on that. But when Mr. Boyd brought that up, we didn't get a chance to object that. Now, there would be some things that we would say about that. So I object to that being considered by the court. Because
It won't be. And the amount of drugs weighed was 1.3 grams. According to this probable cause affidavit.
would you like to tell the judge something?
On the days I missed my reports, they were doing my own time. That's what I spoke
I'm
to.
not going to consider it.
I spoke to her about it.
Yeah, almost like consider against you. How can you report when you're in custody? Why? That's impossible. All right, this state is asking for 8 years in prison, and the defense is asking for continued probation. From probation office, anything you would like to add, ma'am?
This may be a first, Your Honor, but I actually think that Mr. Grant should be continued on probation. Prior to this incident, he was actually doing really well. He had not failed to report. He's on the high medium risk caseload. That's my caseload. He was going to MRT. He was working. He was making payments. He had worked some community service. And so I do think that Mr. Grant can be successful. I think that if we're looking for some form of punishment in this regard, cognitive track of ISF may be appropriate recommendation. But I believe that Mr. Grant can be successful if he's getting the opportunities.
So what is it that he needs? What is it that we can do that is different from what we're doing up to now to prevent further?
I think the cognitive track of ISF is a 90-day program, as you know. He would be in custody until he went. He would be there for 90 days. He would come back to my caseload. I would still insist upon him taking and completing MRT. He would have to report more frequently. He would have to do regular check-ins with me. And honestly, I would examine from there to see if there were any additional classes or things that he might need to assist him. But ultimately, his attitude with me, he's been with me since July of 24. His attitude has been good, truly. He has always spoken to me that he wants to do better, and I have seen his effort, whereas in other people on my caseload, it's not always that case. But Mr. Grant genuinely is trying. And I see that.
Your Honor, I just note that
On this drug case?
that still leaves the new case.
Right. And that
there,
is the
which
issue.
we're not offering a probation on. That obviously, you could plead to the court, and but
That is the issue.
Ma'am, what do you mean?
That is the issue. Is that obviously he wouldn't be able to go to ISF if he has a pending case. And if we're not considering placing him on probation, that is the ultimate problem. Maybe, he's convicted and he sits the time required and then gets out because he's on a 10-year probation, with engaging in organized criminal activity. So we could continue him on probation, but let him sit the time for the new possession. It can be viewed as upfront time in that regard. Maybe so it can be cemented a little bit stronger in his brain that if he continues this is where he's headed. But ultimately, I think that Mr. Grant is better and can do better.
Do you want to get out and move on with your life
Yes, sir.
and with your family?
Yes, sir.
Or do you want to continue probation?
Stay to continue my life, finish probation, be home with my family, kids. And I had got some help to deal with the drug choice too.
Sir,
I said I also had got some help, like been speaking with the mental health with my about the drug choice for me not to want to do any drugs while on probation. And they prescribed me on some mental health pills and they've been helping me with like my anxiety, depression, not doing that.
you're taking mental. Does that have anything to do with competency or insanity in these cases?
Judge, I'm not aware of what he's taking, but I haven't seen anything to indicate that he's incompetent or incoherent. I think that this is probably to treat his drug problem, not to make.
What are we going to do on the new case? Stace.
Yeah, our state was offering state jail time, and it has not accepted that.
I understand.
We certainly could do that today, Judge. Under that scenario, I believe it would be conviction as opposed to a probation.
He's got 167 days credit on the NTRP, which is, and then 88 on the new case. The state jail felony, which is, but at the end of the day, what is it that the probation supervision can give you that you don't already have? That is the willingness to do the right thing. You know right from wrong. You knew fiddling around with drugs, especially methamphetamine, was going to be catastrophic to you and your family's existence. You know better? Do you? And that's, the others are just parts, other non-penal code related, non-criminal act violations. So this is the big problem. All right. Anything else? If not, here's what I'm going to do. I'm going to send you back to your family. Okay. On this second amended motion to revoke probation, I'm going to find there is sufficient evidence supporting the granting of it, as allegation 1 has been pleaded to by the defendant voluntarily, knowingly, intelligently. I find that the motion to revoke second amended motion to revoke probation should be granted by preponderance of the evidence based upon the defendant's violations in number 1. And thus your probation is hereby revoked. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 2 years, which is the minimum. You have 167 days. You may be getting out. That is going to be credited toward your sentence, and that should move a long way toward you getting back to your family. Like you say, you were convicted when we put you on. It's your choice. You know what's right. You know who to fiddle around with, and what is the wrong thing is not in the best interest of your family. And you know the people you run around with will bring you down to the lowest common denominator. You're only as good as the worst person. You've got a family at home. You've got to act mature and think of that as the role model for the children. So I cut you a break on this. Make the most of it. What are we going to do on this? I'm sorry. What are we going to do on this 24 CR 1811, the new indictment? He's got 88. No. Yeah, he's got 88 days credit on the new indictment.
Judge, we've been negotiating and we have an offer for Mr. For the defendant to plead guilty to the new case for 8 months.
Is that what you want to do?
Yes,
All right, write it up. This will run concurrently with each other.
Yes, sir.
Okay. Write it up. Thank you.
Can I be dismissed, John?
Yes, ma'am. Fine. Thank you so much for all you do at the probation office. Is John working on something in the back? Yeah. Okay. On now call 24-CR1811, the state of Texas versus Ja'Cory Grant. That's you. With Mr. Grove, your attorney, and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed in summary?
Yes, sir.
In summary, this indictment, sir, alleges that on or about April 16th, 2024 in Jefferson County, Texas, you committed the state jail felony of illegal possession of a controlled substance, namely methamphetamine. Do you understand what you were charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
Agreements reached where you would be pleading guilty, sentenced to 6 months in the state jail to run concurrently with the previous case. Is that your understanding of the agreement?
Yes, sir.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, sir? Guilty or not guilty?
Yes.
Are you pleading guilty voluntarily? That is, on your own free will and because you are guilty. I'll show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it. Discuss it with your attorney. Are the contents all true and correct?
Yes.
State's Exhibit 1 is tendered into evidence
No objection.
without objection admitted. Among other things, the states you were mentally competent to enter the guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You were giving up your rights to trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were satisfied with the representation provided by your lawyer. All of this is true, so help you God. State's Exhibit 1 is made a part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I am going to follow this agreement and find, sir, you were pleading guilty in the state jail felonies case voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt, and I now find you guilty beyond a reasonable doubt in this case. I am following this agreement. You are hereby sentenced to confinement in the state jail for 6 months. This sentence shall run concurrently with the preceding case that you entered a plea in earlier this afternoon. Do you understand what has happened today, sir?
Yes, sir.
All right, good luck to you, sir.
Thank you.
Do better. There are several cases involving Mark Zachary. Is it Bender? Bender. 4 motions to revoke probation, correct?
Yes, sir.
Okay.
Yeah. Let's
take them in numerical sequence. 19-33421. 21-37960, 21-37961, and 22-40675 are all called. Each of these, 19-33421. On each of these cases, does the defendant, who's here with Ms. Minaldi, his attorney, and the state's attorney, waive formal readings of the motions to revoke unadjudicated probation? Can we proceed in summary?
Yes, Judge.
In summary, 33421 states that, and by the way, raise your right hand, sir. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. This motion, in this case, filed February 21st, 2025, states that on May 25th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation for the third degree felony of unlawfully carrying a prohibited weapon. Do you understand what this alleges, and is that true?
Yes, sir.
I want to go on.
Wait, I just did number one on the.
Well, number one on each of, number one states you committed the offense of illegal possession of marijuana on or about October 8th, 2024 in Chambers County, Texas, in violation of your probation order, condition 1. Is that true or untrue?
True.
Are you pleading true to this voluntarily and because it is true?
Yes, sir.
You understand that a voluntary and knowingly made plea of truth for one or more violations of probation, that's enough to grant the motion to revoke probation. Your probation could be revoked and you could be sentenced to the full range of punishment, which is a third degree felony, no less than 2, no more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you were pleading true voluntarily. You understand and appreciate the consequences of pleading true. And God bless this machine. All right. An agreement's been reached where your probation would be revoked. You would be found guilty, sentenced to 3 years in prison to run concurrently with other cases. Is that your understanding?
Yes, sir.
It's like one case will be dismissed.
Misdemeanor.
24, okay.
Yes, sir.
Is that your understanding?
Yes.
Okay, these other ones, what's going to happen?
Same resolution for all.
Okay. This, and the sentences to run concurrently, right?
Yes, Judge.
Okay, this isn't here on this. Do you want to put that included on the, agreed recommendation?
Me too. I apologize, Judge.
Okay, I'm going to put an X and it's with these 3, right?
Yes, Judge. So I have them if you want me to read them to you. F21-37960, F21-37961, and F22-40675.
I think I got those. Okay, this is going to run concurrently with 3 other cases. If I follow this agreement, sir, you have no right of appeal in your cases. Do you understand?
Yes, sir.
We're going to show you what's marked as States Exhibit 1. Did you sign that
Yes, sir.
agreement? Understand it? Discuss it with your attorney? Are the contents of States Exhibit 1 true and correct?
Yes, sir.
States Exhibit 1 tendered into evidence without objection admitted. This essentially states you're admitting wrongdoing here and admitting to the motion to revoke unadjudicated probation as a violation of probation that can revoke you, and this will be the same for all cases. And you understand that you are giving up all rights of appeal if I follow this agreement, which I'm going to do in each case.
Yes, sir.
So States Exhibit 1 is made a part of the record for all purposes, pre-sentence reports waived and all of this. I'm going to find there is sufficient evidence supporting this motion to revoke probation to grant it by preponderance of the evidence or greater as allegation 1 is proven true, voluntarily and knowingly made by the defendant. Your probation is revoked. And in this case, your plea of guilty that placed you on deferred or unadjudicated probation in 2023 was made voluntarily, knowingly, intelligently. There was enough evidence supporting your guilty plea from States Exhibit 1 admitted at the plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. In this case, 33421, I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. This will run concurrently with all the other cases. Do you understand what has happened?
Yes, sir.
Now, we're going to do it a little different on the others so you know where you are. We're going to do the same thing in each case, but I'm going to hold off the findings until the end and do them all together, okay? So 21-37960, 21-37961, and 22-40675. Those are all similar to the previous case.
Yes, there is an amendment we need to make on 40675 in the paragraph that starts with that Mark Binder, defendant in the above style cause, it says it's a possession of a controlled substance, a state jail felony. It should be possession of a controlled substance, a third degree felony on the first page. On the first page where it says state jail felony, it should say a third degree felony. All of these are third degree felonies. And I missed that whenever I signed the motion or vote.
You did.
I did. I missed it.
It's okay, Judge.
Yes. There's always a woman that catches my mistakes, Jason.
Okay, that has been corrected to a third degree felony on this date without objection. All right, in each of these three motions, 37960, 37961, and 40675, these are motions to revoke unadjudicated probation. Does the defendant waive formal readings of these motions? Can we proceed in summary?
Yes.
In summary, they similarly allege, and any objection to putting them together here, that on May 25th, 2023, in this court, you were placed on 10 years deferred or unadjudicated probation in each case for the third degree felonies of illegal possession of a controlled substance. Is all of that true and correct, sir?
Yes, sir.
Allegation number one in each case alleges similarly in the previous case that you've pleaded true to already and has been sentenced, that you committed the offense of illegal possession of marijuana on or about October 8th, 2024 in Chambers County, Texas, in violation of condition one of your probation orders in each of these cases. Is that true and correct in each case?
Yes, sir.
Are you pleading true and correct voluntarily, knowingly, intelligently, and because these allegations are true?
Yes, sir.
Do you understand that a voluntary and knowingly made plea of true to one or more violations of probation? That's enough to grant the motions to revoke probation by a preponderance of the evidence or greater. Your probations can now be revoked. You can be found guilty and sentenced up to the full range of punishment. These third degree felonies carry with them a punishment range of no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000. That's the punishment range in each case. Do you understand what you're exposed to?
Yes, sir.
By pleading true, and there are plea agreements in each of these cases that have been entered by the parties, agreed upon by the parties, where your probations would be revoked. You would be found guilty in each of these cases, sentenced to 3 years imprisonment on each case to run concurrently. Is that your understanding of the master plan?
Yes, sir.
In all these cases. If I follow these agreements, sir, you have no right of appeal of your cases. Do you understand?
Yes, sir.
Once again, on each of these cases, including the original one, are you pleading true to allegation one, committing the offense of illegal possession of marijuana in violation of condition one of your deferred order?
Yes, sir.
That's allegation one in each of these cases. These 4 cases, these 3 we're working on, and the 4th one that you originally pleaded true to a little while ago. Are you pleading true voluntarily, knowingly, intelligently, and because these allegations are indeed true and correct as they are alleged?
Yes, sir.
Stand by them.
Thunder?
I think it is. This is all I've had. Was coffee all day, and my stomach is rebelling. Everybody,
I thought that was a comment on.
everybody at home, take shelter. If I follow these agreements, sir, not to be lied about, you have no right of appeal, and I'm sorry about that. On each of these cases, I'm going to show you what's marked as State's Exhibit 1, and I'm going to ask you if you signed each of these documents voluntarily, knowingly, intelligently, discuss them with your attorney, or the contents all true and correct.
Yes, sir.
State's Exhibit 1 is admitted on each of these cases, which states you are mentally competent to enter your pleas in these cases, which are freely and voluntarily made, and you are admitting guilt to these violations, and that you are have discussed all of this with your attorney, and you are satisfied with the representation of your attorney in each of these cases, and all of this is true, so help you God, as well as you are giving up all rights of appeal if I follow these agreements,
Yes.
which I'm going to do. All right. Anything else to add?
No.
If not, I'm going to find in each of these three cases, including the fourth one that has already been disposed of in the cases of Mark Zachary Binder, the defendant has pleaded true to allegation one in each of these motions to revoke probation voluntarily, knowingly, intelligently. That is enough to grant these motions to revoke probation by a preponderance of the evidence or greater. It is so ordered, and these motions are hereby granted. Your deferred or unadjudicated probations in each of these cases are hereby revoked. In each of these cases, you pleaded guilty voluntarily, knowingly, intelligently, when you made your pleas. In these cases, when you were placed on probation on or about May 25th of 2023 in this court, you were mentally competent to do so. You understood and appreciated the consequences of pleading guilty. There was sufficient evidence supporting your guilty pleas in each of those cases at that time to find you guilty beyond a reasonable doubt when we placed you on deferred or unadjudicated probation. Now that that is revoked, you are hereby found guilty beyond a reasonable doubt in each of these cases. I am following the agreements in each of these cases. You were hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 3 years. These sentences shall run concurrently. Do you understand what has happened today, sir?
Yes, sir.
Anything else to add by the
No.
parties?
No, Your Honor.
Then we are in recess on this case. Thank you.
Thank you.
Yeah.
No.
Happy? Oh, you're Gary Hayden Bass here with Mr. Adams, your attorney and the state's attorney. Looks like there's a motion to revoke probation that's pending, right?
Yes.
What are we going to do today? It says a motion of motion hearing, right? Everybody ready?
Yes, sir. State's ready.
Okay, it's unagreed is what it is?
Yes, sir.
Okay. 24 CR 481 is now called
Okay.
the state of Texas versus Gary Aiden Bass. That's you?
Yes, sir.
Sir. And you were here with Mr. Adams, your attorney and the state's attorney. Does the defendant waive a formal reading of this motion to revoke unadjudicated probation? Can we proceed in summary?
Yes, sir.
Sir, raise your right hand. Do you solemnly swear or affirm any statements you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Lower your hand. In summary, this motion to revoke unadjudicated probation filed on September 24th of 2024 alleges that on June 3rd of 2024, that you were placed on 10 years deferred or unadjudicated probation in this court for harassment of a public servant, a third-degree felony. Is all of that true?
Yes, sir.
One, states you failed to report to the Jefferson County Probation Office on June 3rd, 2024 in violation of condition 4 of your deferred order. And that deferred order states report is directed by your probation officer and obey all rules and regulations of the Jefferson County Community Service Community Supervision Office, Probation Office. So is that allegation true or untrue?
It's true.
Are you pleading true voluntarily and because it is true?
It's true.
Do you understand that a voluntary and knowing plea of true to one or more violations of probation, that's enough to grant the motion to revoke probation? Your probation can now be revoked. You can be found guilty and sentenced to the full range of punishment, which is no less than 2 nor more than 10 years confinement in prison. Knowing that, do you insist on pleading true today?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. There are some other violations of probation that the court is interested in. Community service hours. Number 3, it states you failed to provide verification of performing community service hours as required. And is that true or untrue?
It's true.
Are you pleading true to that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
You understand what the consequences are by a plea of true. We talked about that before. You failed to enroll, number 5, you failed to enroll in services at Spindletop Center and follow the recommended treatment plan in violation of probation condition 36 of your order. Is that true?
Yes, sir.
Are you pleading true to that voluntarily, knowingly, intelligently, and because it is true?
Yes, sir.
Why is that? Why did you fail to enroll in the services at Spindletop?
Because I was trying to get back to Harris County. Jasper County came and picked me up from Jasper County, took me to Beaumont to give me a psych evaluation. I didn't want to. I'm out of Harris County, at Harrison. And so I was trying to get back to Harris County. So they were telling me, hang on. The nurse was telling me, hang on, let me get the doctor and talk to him about it. So when I took the IV out of my arm, I was walking to the exit, and they told me to plead, don't move, we're
Yes, sir.
going to get you help.
Okay.
And I told them no, you know what I'm saying? So they said, we're going to call security. And they saw the security
That's what happened.
strapped me down to a psych chair. Hands, feet, arms, you know what I'm saying?
Yeah.
So I'm strapped down to a psych chair, but I have methamphetamines inside my system. I was freaking out.
Okay.
So I turned over and spit on the security guard. So I was paranoid. I didn't know what was going on.
Okay. 6. Number 6 states you committed the offense of evading arrest with a motor vehicle out of Harris County, Texas on or about September 7th, 24. 7 states on that date in Harris County, Texas, you committed the offense of unauthorized use of a motor vehicle. And also, number 8 in the motion to revoke probation states you failed to remain in Jefferson County, Texas on or about September 7th, 2024, where you were required without the permission of the Jefferson County Probation Office. And 9, you were at a location other than your residence at approximately 11:40 p.m., which was beyond your curfew. All of those 4 allegations are in violation of your probation order, 6, 7, 8, and 9. Is that true or untrue?
He's referring to.
John, I'm going to abandon count 6.
Okay.
Harris County has only found the other amount.
7. What about the unauthorized use of a motor vehicle? Was that true?
Me and my homeboy was in the car, but I was in the passenger seat. He was driving.
He's already been found guilty in Harris County on this charge, Judge.
By a trial?
It's, I believe it was a plea.
Is that right?
He entered,
Did you enter a
pleaded
plea?
guilty on
Of
January
guilty?
8th.
They
For that?
gave me PO bond to sign. I signed for a PO bond, pre-release.
No, that's not what we're talking about. Did you enter a plea of guilty in Harris County
Yeah.
to that charge?
He said yes.
Yeah.
Yes, sir.
And what was the disposition?
Nothing.
Just a copy of the judgment from that judge.
No, this states you were found guilty. It was reduced to it under 12.44 of the Texas Penal Code to a state jail felony. You got 1 year. It was a state jail felony reduced to time under county, and you received 1 year in the county jail.
Yes, sir.
Well, you didn't remember doing that? You said told me just then you didn't. You got this. This was a disposition back on January. So all of that is true.
Yes, sir.
Okay. All right. So then number 7 is true. You've committed the offense of unauthorized use of a motor vehicle in Harris County that you ended up pleading guilty to.
Yep.
Correct?
Yes, sir.
Are you pleading true voluntarily and because it is true?
Yes, sir.
And the same thing, you understand, 1 or more violations of probation, that's enough to grant the motion to revoke probation. Your probation can be revoked and you can be sentenced up to the full range of punishment. And then finally, 8 states on September 7th, 2024, you failed to remain in Jefferson County, Texas, as you were arrested in Harris County, Texas, without the permission of the Jefferson County Probation Office that you had to have to leave Jefferson County, Texas. Is that true?
Is that true or not true?
So we picture a person.
This states you failed to remain in Jefferson County, Texas, that was required of you in your order of probation by being in Harris County, Texas on September 7th, 2024 without the permission of the Jefferson County Probation Office. I guess that's when you were arrested for unauthorized use of a motor vehicle that you pleaded true to. Is that true too?
Yes, sir.
Okay. So are you pleading true then again to allegations 1, 3, 5, 7, and 8 voluntarily, knowingly, intelligently of this motion to revoke unadjudicated probation and understanding that the court could revoke your probation and you could be found guilty and sentenced up to the full range of punishment for this third degree felony, no less than 2, no more than 10 years confinement in prison. Knowing all of that, do you insist on pleading true to these allegations 1, 3, 5, 7, and 8 of the motion to revoke probation?
Yes, sir.
I find you are pleading true to those allegations voluntarily, knowingly, intelligently, and because those are true. All right. Is there an agreement here? No. What says the defense?
Your Honor, we're gonna ask that you continue him on supervision. And I was going to allow my client, he did admit to those allegations as you named, the 1, 3, 5, 7, and 8. However, we have compelling reasons as to why we're asking you to keep going supervision. All right, so Mr. Bass, all right. In this particular case, you heard the court ask that we have any kind of plea agreement, right? And the state had offered you 3 years in the institutional division as an offer on this case. And you remember signing this rejection saying you didn't want to take that offer and you signed your name on it, right? So when you signed that rejection, when you signed that rejection, you wanted to go open to our judge so he could make the decision, right?
Yes,
All right. So to give him a reason and good reasons as to why he might want to keep you on supervision, let's talk about some things. One of the things that was emailed to me in this case was your psychological evaluation. Well, it's more than one psychological evaluation. You have had, you've had an extensive history of mental illness. Is that correct?
Yes, sir.
And with that extensive history of mental illness, and you can tell me specifically about yourself because you know you better than anybody, right?
Yes, sir.
All right. Do you remember? And I think this examination was by a Brent Wortham PhD in 2020. You evaluated in the Texarkana Center Developmental Disabilities Center. Do you remember that?
Yes, sir.
Thank you.
Right. And when you were evaluated there was some issues that the person had came up with you, the doctor had diagnosed you with. And one of those was adaptive behavioral level. And he talks about you having some cognitive issues with your, and I'm gonna be specific, intellectual disability, developmental disorder, where you
IDD.
IDD. Do you remember that diagnosis?
Yes, sir.
So when it comes to your ability to understand things and comprehend things while you've been on probation, can you tell the judge in your own words what's some of the things that you haven't been able to understand that's been difficult for you? Well, you know, with that diagnosis, have you been having any problems?
Yeah,
Go ahead.
since I was about maybe 15, 16 years old, I was in a group home in Lubbock, Texas. And when I got to Houston, I started falling off. I started going around, going to school, smoking dope, doing drugs, hanging out with the wrong people. And that's what made me go downhill. I'm saying that's what made me go to jail. And that's what made me,
We're going to talk here from time. Now, let me ask you some questions. So as you bring an issue, but were those choices you made?
yes, sir, I made them choices because I felt like I was, I had the mindset of, I felt like I was growing up, but I felt like my mindset of people in my family kept telling me I'm still a kid.
Well, but you knew right from wrong, right?
Yes, sir.
Okay.
And
You were running around with a bad group?
Yeah.
You know, my dad used to tell me, you're going to only be as good as the worst person in the group you run around with. So that's why you want to always deal with people who are better than you. They help you make better choices.
Yes,
By,
sir.
okay.
And I understand that you were given medications, and this is at least as of June of 2023. I think you had the several medications for your mental health issues. Were you able to take those medications while you were on supervision?
Yeah, because I was getting handed to me.
All right. And if judge continues you on supervision, some of those issues that you got with your mental health, would you continue to take those?
Yep.
All right. And then on top of that, why are you asking judge? I know you said no to the 3-year offer that the state made. I got that. So why are you asking judge to continue you on supervision? In your own words, why?
That, I mean, I'm the reason why I'm asking the judge, because I know I messed up. I know we put this up, but we can backtrack and fix it. You know what I'm saying? We can't go to the past and, you know what I'm saying?
Sure.
It's the present.
That's right.
I'm trying, this is, I've been going through a whole life, growing up, family situation. I just want to just sit down and relax and just chill for a minute and just think what I'm going to do and do it. Because I want to work, I want to get a job, I want to make some money so I have money in my pocket. I'm saying, I want to give me a house to live in. I want to change my whole, you know what I'm saying? I don't want to go through this no more.
Right. And we have a lady to my, I guess it'll be right, who's here with Spindletop MHMR. If judge continues you on supervision, would you be willing to work with her with Spindletop MHMR?
Yes, sir.
And would you follow appointments to do what you're supposed to do?
Yes, sir.
And would you be a danger to the society or anything like that?
No.
And with your probation officer to my right, would you listen to her and follow instructions?
Yes, sir.
All right. And do y'all have a relationship?
I never.
You'll never seen her. Okay, all right. So the bottom line is, would you be willing to listen to her and do what she asks you to do?
Yes, sir.
So you're asking the judge to give you one more shot. Yeah.
Yes, sir.
Let's get one thing though. We've talked about mental issues. The defendant is not declared incompetent. He's competent to stand trial. He has not ever been ruled insane.
Right.
Okay. And he was on the mental health caseload while he was on probation here in June of 2024.
He was
But
ordered.
didn't work long during on that probation.
He was ordered. He's never reported. The state saw all those issues at the time in which I made the initial plea agreement with Miss Mantellini, and that was to place him on a mental health caseload because we saw what the issues were. We can't help somebody who won't help himself. The man never reported, never did anything. Instead, he went out and committed new offenses. I haven't heard one thing that tells me he's going to do anything different than what we just did.
What is your recommendation?
Judge, we can't help somebody that won't help himself. So the only recommendation I can make is prison time.
For how long? Yes.
I offered the opportunity for them, as Mr. Adams pointed out multiple times. I gave him an offer of 3 years. He didn't want that. I leave it to the court to the determination as to how much time, but I don't feel safe representing Jefferson County suggesting that we give him another opportunity to commit more offenses.
Mr. Bass, anything you would like to add?
I'm just fed up being in custody.
Yeah, I bet.
I want to do the right thing and don't come back. I know if I go to a group home, I'm gonna stay in that group home that I'm assigned to. I'm gonna stay in that group home and follow the directions of what they got going on.
Okay. Well, after the group home though is completed, what are you going to do?
Try to give me a job, get on my feet.
Well, we understand that we've gave you this chance. You were charged with third-degree felony harassment of a public servant. Then you never reported, and you admitted to committed another offense of unauthorized use of a motor vehicle in Harris County. What did they? Is that just pending in Harris County?
No, Judge, they resolved both those cases with the judgment I showed, Your Honor.
Okay. And
They dismissed that evading and gave him some jail time on the.
the unauthorized use.
Yes, sir.
And then you
To be
got in
specific,
trouble in Harris County because you didn't obey the orders here, and you've admitted to 1, 2, 3, 4, 5 separate violations, including one new crime, and failing to even report one time to the probation office, which we can't help you when you don't show up for work. You're going to get fired. That's what happens. All right, if nothing further, here's what the court's going to do. The court's going to find that there is sufficient evidence supporting this motion to revoke unadjudicated probation, to grant it by preponderance of the evidence or greater, as allegations 1, 3, 5, 7, and 8 in this motion to revoke unadjudicated probation have been proven true by preponderance of the evidence or greater, as the defendant has voluntarily, knowingly, and intelligently admitted responsibility for committing those violations, including unauthorized use of a motor vehicle, a crime. Thus, the defendant's deferred or unadjudicated probation is hereby revoked. Earlier in this case, the defendant pleaded guilty to harassment of a public servant voluntarily, knowingly, and intelligently. There was sufficient evidence supporting his guilty plea from State's Exhibit 1 admitted to find him guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this third-degree felony based upon the allegations in this motion to revoke unadjudicated probation that you have admitted. Your probation is revoked, and you are hereby sentenced to confinement in the institution of division of the Texas Department of Criminal Justice to serve a term of 2 years, the minimum. You will be given credit for all time you have served. I have 207 days credit, and that should be well toward satisfying this this time of 1 quarter. That's more than a quarter of 730 days.
yes, sir.
And you may be being released here pretty shortly, Mr. Bass. You'll be getting credit for all this time. Anything else?
No, thank you, Your Honor.
All right.
We appreciate
That is all. Thank you.
it.